So the examples that have been provided that are supposed to be proof that payments made outside the SDUs or the state or gifts are very specific. Okay, so according to the judge's guide to child support, generally, as a matter of law, an obligor should not be allowed credit for expenditures made while the child is in his or her custody, or for other voluntary payments made on behalf of the child that do not conform specifically to the terms of the decree. A decree is an official order issued by a legal authority. So they're saying they're not allowed to give credit for any money spent while the child is in their custody, other than voluntary payments, because it's outside of the decree. Well, if you don't have a decree, if you haven't been in court and there's no court order, then they can't consider it a gift. You haven't been ordered to pay anything. They're saying, okay, if you're ordered to pay $250 a month and you pay $100, or you buy your baby $100 worth of something, they're going to consider that a gift because it wasn't in the child support order or the divorce decree. Well, at the point where you're going to establish, you go to court because you've been sued for child support, and they're saying that you refuse to provide, and you're saying, yes, I do provide for my children. It's not outside of any decree because these have not been filed. These are not ordered. So how are you breaking a decree? You're not. So how are they going to call your payments a gift when there's no order in place? And this is based on a matter of law. Another thing, since there has not been a child support order issued yet, any payments or monies paid by the non-custodial parent to the custodial parent on behalf of the child is most definitely child support because there is not a court order in place. No, I haven't seen that. I've heard a lot about it over the years. C1. Next, according to the judge's guide, credit for a voluntary payment permits the absent parent, there we go, absent parent to vary the terms of the decree and usurps the custodial parent's right to determine the manner in which support money will be spent. There's that word decree again. Again, if you're being sued, there's no order yet. So that money is not a gift. That is support. So if they throw your case out saying, oh, you can't do that, well, you said there's no order yet. If there's unmarried, if you are unmarried or there's no divorce, then it's not accurate for them to just throw your information out because, again, there's no court order in place already. So it's not a gift. If the judge tries to accuse you of being absent and you have proof that your child is being alienated from you, which is very common, unfortunately and sadly, parental alienation is rampant. You let them know. When you make a phone call, you try to pick your child up and you're being alienated, keep a notebook, keep a calendar, call such and such date, time, leave your voicemails, have that, because you can't be absent and be alienated at the same time. It just is, you can't, those two don't go together. So you always want to document, especially if you're going through this, you always want to keep all the documents. If the judge still orders you to pay, orders a judgment against you, file again for appeal immediately, along with the motion to dismiss.